Rule 130, Section 1. Objects as evidence. Objects as evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibit to, examined, or viewed by court. Section 2. Documentary evidence. Documents as evidence consist of writing, recording, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their content. Photographs includes still pictures, drawing, stored images, X-ray film, motion picture, or video. Section 3. Original document must be produced exemption. When the subject of inquiry is the content of a document, writings, recording, photographs, or other record, no evidence is admissible other than the original document itself, except in the following cases. A. When the original is lost or destroyed or cannot be produced in the court without bad faith on the part of offeror. Second, when the original B. When the original is in the custody or under control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes or procedures. C. When the original consists of numerous account or other documents cannot be examined in court without great loss of time, and the facts sought to be established from them is only the general result of the whole. Letter D. When the original is a public record in the custody of a public officer or it's recorded in a public office. The last is when the original is not closely related to controlling issue. Section 4. Original of a document. An original of a document is the document itself or any counterpart intended to have the same effect by a person executing or issuing it. An original of photographs includes the negative or any print therefrom. If data is stored in a computer or similar devices, any printout or other output readable by sight or other means shown to reflect the data accurately is the original. A duplicate is a counterpart produced with the same impression. The same impression as the original or from the same matrix or by means of photography, including enlargement in miniature, or by mechanical or electronic recording, or by chemical reproduction, or by other equivalent techniques which accurately reproduce the original. Section 5. When the original document is unavailable. When the original document has been lost or destroyed or cannot be produced in court, the offeror, upon proof of its execution or existence, and the cause of its is unavailable without bad faith on his or her part, mm, may prove its content. May prove its content by a copy, by recital of its contents in some authentic document, or by the testimony or witnesses in the order stated. Section 6. When the original document is an adverse party's custody or control. If document is the custody or under control of the adverse party, he or she must have reasonable notice to produce it. If after such notice and after satisfactory proof of its existence, he or she fails to produce the document, secondary evidence may be presented as in the case of its loss. Section 7. Summary. Section 7. Summary. With the contents of documents, records, photographs, or numerous accounts are voluminous and cannot be examined in court without great loss of time, and the facts sought to be established is only the general result of the whole. The content of such evidence may be presented in the form of a chart, summary, or calculation. Rule 131, Section 1. Burden of proof and burden of evidence. Burden of proof is a duty of a party to present evidence on the fact in issue necessary to establish his or her claim or defense by the amount of evidence required by law. Burden of proof never shift. Burden of evidence. Burden of evidence is a duty of a party to present evidence sufficient to establish or rebut a fact in issue, to establish a prima facie case. Burden of evidence may shift from one party to other in the course of the proceeding, depending on the exigencies of the case. Section 2. Conclusive presumption. The following are instances of conclusive presumption. Whenever a party has, by his or her own declaration, act or omission, intentionally and deliberately led another to believe a particular thing's true, and to act upon such thing belief, he or she cannot, in any legislation arising out of such declaration, act or omission, be permitted to falsify it. And the second is, the tenant is not permitted to deny the title of his or her landlord at the time of the commencement of the relation of the landlord and tenant between them. Section 3. Disputable presumption. The following presumption are satisfactory if uncontradicted, but may be contradicted and overcome by other evidence. A. That a person is innocent or crime or wrong. Second, that an unlawful act was done with an unlawful intent. C. That a person intends the ordinary consequence of his or her voluntary act. Or that a person take ordinary case of his or her concern. Section 4. No presumption of legitimacy or illegitimacy. There is no presumption of legitimacy or illegitimacy of a child born after 300 days following the dissolution of the marriage or the separation of the spouses. However, alleges the legitimacy or illegitimacy of such child must prove his or her allegation. Section 5. Presumption and civil action and proceedings. In all civil action and proceedings not otherwise provided for by the law or these rules, a presumption imposes on the party against whom it is directed the burden of going forward with evidence to rebut or meet the presumption. If the presumption are inconsistent, the presumption that is founded upon upon weight consideration of policy shall apply. If consideration of policy are of equal weight, either presumption applies. Section 6. Presumption against an accused in a criminal cases. If a presumption of facts that establish guilt is an element of the offense charged or negates a defense, the existence of the basic fact must be proved beyond reasonable doubt, and the presumed fact follows from the basic facts beyond reasonable doubt.